Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today we're covering Hamm v. Smith, case number 24-872, decided May 21st, 2026. And this one took an unusual turn. The court dismissed the writ of certiorari as improvidently granted, what lawyers call a DIG, no reasoning provided, just 2 sentences. Per curiam opinion, Justice Sotomayor wrote a concurrence joined by Justice Jackson. Justice Thomas dissented, and Justice Alito wrote a dissent joined by Justice Thomas, with Justice Gorsuch joining parts 1 through 3.
A DIG means the court granted review, heard oral argument, then basically said, never mind, we shouldn't have taken this case. That almost never happens. The court granted review to address how courts should evaluate multiple IQ scores when determining intellectual disability for death penalty cases. But oral argument revealed massive problems with the case as a vehicle for deciding that question. This matters because Joseph Smith, a death row inmate in Alabama, won protection from execution in the lower courts. The dismissal leaves that protection intact. He cannot be executed. But it also leaves courts nationwide without guidance on a recurring question in death penalty litigation.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. Here's what you need to know. I'll toss it to you. Who's Joseph Smith and how did he end up on death row?
Back in 1998, Alabama convicted Joseph Smith of first-degree murder. During his sentencing hearing, Smith presented evidence of intellectual disability. A psychologist administered an IQ test that yielded a score of 72. The test administrator explained that the standard error of measurement, that's the margin of error built into every IQ test, meant Smith's actual IQ could range anywhere from 69 to 75. He also brought school records showing 2 earlier IQ tests. Those earlier tests produced scores of 75 and 74. School officials classified Smith as educable mentally retarded during 7th grade. So at sentencing, Smith presented 3 IQ scores, 75, 74, and 72, all pointing toward potential intellectual disability. But this all happened in 1998, when the law allowed executing intellectually disabled defendants as long as the sentencer considered that disability as mitigating evidence alongside other factors.
Right? Because Atkins versus Virginia, that's the 2002 case that categorically barred executing intellectually disabled people, didn't exist yet.
Correct. The jury recommended death. The trial judge imposed that sentence. The Alabama Supreme Court affirmed. Smith sat on death row.
Then Atkins happened.
Then Atkins happened in 2002. The Supreme Court held that executing intellectually disabled individuals violates the Eighth Amendment. The court largely left it to states to develop their own standards for determining intellectual disability. Alabama responded by adopting a 3-pronged test requiring defendants to prove by preponderance of the evidence. First, significantly sub-average intellectual functioning, an IQ of 70 or below. Second, significant deficits in adaptive behavior. And third, that both manifested before age 18.
And Smith went back to court arguing Atkins protected him?
Right. He filed for state post-conviction relief in federal court, arguing he met Alabama's definition of intellectual disability and the Eighth Amendment barred his execution. The Alabama trial court denied relief without even holding a hearing. The Alabama Court of Criminal Appeals affirmed. Alabama Supreme Court denied review. He petitioned for federal habeas relief in the district court for the Southern District of Alabama. The district court initially denies his petition. Smith appeals to the 11th Circuit, which reverses and remands, holding the district court wrongly deferred to the state court decision. The 11th Circuit orders the district court to conduct a novo review, meaning fresh review without deference, of whether Smith meets Alabama's intellectual disability standard.
And Alabama doesn't appeal that to the Supreme Court?
They don't. So on remand, the parties agree to an evidentiary hearing. Both sides hire new experts to administer fresh IQ tests. Alabama's expert, Dr. King, administers a test. Smith scores 74 with a 95% confidence interval ranging from 70 to 79. Smith's expert, Dr. Fabian, administers a different test. Smith scores 78 with a confidence interval ranging from 72 to 83.
Wait, so now he's got 5 IQ scores total? The original 3 from years ago, 75, 74, 72, plus these 2 new ones, 74 and 78?
Exactly. 5 scores spanning many years, all falling between 72 and 78, all technically above Alabama's cutoff of 70. But remember, every score carries measurement error. The question becomes, how do you evaluate multiple scores that all fall in this borderline zone?
And that's what the experts disagreed about?
Completely. Dr. King, Alabama's expert, looked at all 5 scores and concluded Smith's true intellectual functioning fell in the low average range, not intellectual disability. King examined the subscores within each test, noted inconsistencies he attributed to learning disability rather than intellectual disability, and relied on his clinical impression of Smith's presentation and ability to interact.
And Smith's experts?
Dr. Fabian testified that several scores fell in the range for intellectual disability when you account for measurement error. Fabian emphasized you need to consider IQ scores alongside other areas of functioning: academic achievement, adaptive behavior, executive functioning. Looking at everything together, Fabian concluded Smith met the intellectual functioning prong of the disability definition. Smith's second expert agreed, noting the scores fell in the range of what would be considered mild intellectual disability when considering standard error of measurement.
So the district court weighs all this evidence and rules for Smith. The district court found Smith proved by preponderance of the evidence that he satisfied all 3 prongs of Alabama's test. The court found significantly sub-average intellectual functioning, significant adaptive behavior deficits, and manifestation before age 18. The court concluded Smith qualifies as intellectually disabled and cannot constitutionally be executed. And the 11th Circuit affirms using what they called a holistic approach. But plot twist, the Supreme Court vacated that decision in 2024, finding the 11th Circuit's reasoning unclear. The court questioned whether the 11th Circuit applied a per se rule, meaning an automatic rule, based solely on the fact that Smith's lowest scores error range touched 69, or whether it used a more holistic approach considering all relevant evidence including expert testimony. The court asked the 11th Circuit to clarify.
And on remand?
The 11th Circuit clarified in November 2024 that it used a holistic approach. It explicitly rejected any per se rule based on the lowest scores error range. It affirmed the district court's decision, explaining the district court properly considered Smith's IQ test results taken together in context of expert testimony, and the factual findings weren't clearly erroneous.
So Alabama petitions for certiorari, asking the Supreme Court to address how courts must evaluate multiple IQ scores?
Actually, Alabama's cert petition proposed 2 questions. First, whether states can require claimants to prove an IQ of 70 or less by preponderance of evidence. And second, whether courts evaluating multiple IQ scores must find that every valid score of about 75 or less supports an Atkins claim. The court declined to grant either of those questions. Instead, the court granted a different question raised by the United States in its amicus brief: whether and how courts may consider the cumulative effect of multiple IQ scores in assessing an Atkins claim.
Wait, so the court granted a question neither party actually asked?
The United States proposed it on the last 2.5 pages of its amicus brief supporting Alabama's petition. And this decision to grant that specific question becomes really important when we get to what happened at oral argument.
Okay, so the Supreme Court grants review on this cumulative effects question. Oral argument happens December 10th, 2025, and that's when everything falls apart?
That's when the justices discovered this case presents the opposite of what they thought they granted. Let's walk through what happened. Justice Sotomayor opened her questioning by saying, "I'm having a really hard time with this case."
Uh-oh.
She grilled Alabama's on its central premise. She told Alabama's counsel, "I don't see any state that defines intellectual disability this way. I certainly don't see anything in Alabama's law that suggests it's following that rule. You're making something wholesale up."
She more or less accused them of inventing their legal argument. She pointed out that Alabama courts actually do exactly what the district court did here. Look at standard error of measurement. Determine whether the person falls within the range of intellectual disability, considering that measurement error. Then examine adaptive functioning and other factors to make the ultimate determination. She said this approach follows exactly what the Supreme Court told courts to do in Hall versus Florida. That's the 2014 case. And Moore versus Texas. That's the 2017 case.
So she's saying Alabama's asking the court to create a brand new rule that even Alabama doesn't follow.
And then she dropped the hammer. She told Alabama's counsel, "You didn't argue this below. Your own expert did exactly what you say is wrong. Your own expert said he had valid scores between 72 and 78, and he relied on all of the other indicia to determine that he believed this person wasn't intellectually disabled."
Wait, Alabama's own expert used the methodology Alabama now claims violates the law?
That's exactly what happened. Dr. King, Alabama's expert, looked at all 5 scores holistically, considered subscores and clinical presentation, examined adaptive functioning evidence, then rendered his opinion using clinical judgment. That's precisely the holistic approach the district court used and precisely what Alabama now claims courts cannot do.
She asked Alabama's counsel, please point me to somewhere in the record in the district court where you made this argument. Alabama couldn't point to anywhere in the district court record where they argued courts must use specific statistical methods to combine multiple scores. What about Justice Jackson? What did she focus on during oral argument?
Justice Jackson hammered on the preservation problem, meaning whether Alabama actually raised these arguments below. She told the U.S. government's lawyer who argued for Alabama, "I think you may have waived this." Because to the extent that Alabama sat there and heard the experts testifying and didn't object on the basis that you're saying or didn't argue to the district court, there's a problem with this testimony because he's testifying to things that Alabama law doesn't consider. I think you may have waived this.
So Alabama never objected at trial when the experts testified using the methodology Alabama now attacks?
That's the suggestion. And Justice Jackson really drove this home. She told Alabama's counsel, this never came up during, no one said to the district court, please evaluate him using this method. And the district court said no. In that situation, we then assess whether the district court committed error by refusing to adopt that method. But here, Alabama never asked the district court to use the statistical methodology Alabama now claims the Constitution requires.
Justice Jackson's point was the Supreme Court can't reverse based on arguments Alabama never made. She brought up a case the court decided just weeks before this argument, Clark versus Sweeney. In Clark, the court summarily reversed a habeas grant because the appeals court ruled on an argument the petitioner never presented below. Justice Jackson told Alabama, "So I feel like you're actually asking us to violate that same principle. You never asked the Court of Appeals in this case, for example, to evaluate the district court on the basis of these 5 methods and say that it was erroneous on that basis or on the cumulative effects test."
This sounds like a classic vehicle problem. The court granted review expecting one thing but discovered during argument that the case doesn't actually present that issue cleanly.
Exactly. Justice Jackson explicitly said, "I thought the question presented in this case was about the cumulative effects test, and that's what you were actually advocating for, but that didn't come up in the lower courts. So how could we possibly reverse on the basis of these kinds of arguments that were not presented below?"
And what did Justice Sotomayor say about the question presented?
She pointed out the court didn't grant cert on the burden of proof question because that wasn't really disputed anywhere. She then challenged Alabama to name even one state court that requires defendants to prove intellectual disability using the specific statistical methods Alabama now advocates. She said, name one court that has held that it's up to the defendant to prove the first prong by a preponderance of the evidence with some statistical measure. It's not what I see. I have not found one state case that has required that.
So no state actually follows the rule Alabama wants the Supreme Court to announce?
That's what Justice Sotomayor concluded. She told Alabama, "You haven't pointed me to Perkins or any other court where the rule that you're proposing has been adopted by Alabama. When we get that case, we might answer your question, but in the abstract, I don't know how we can answer it here."
Okay, so let me make sure I understand what went wrong here. The court granted review expecting a clean methodological question about how courts handle multiple IQ scores. But oral argument revealed. First, Alabama never actually argued below what they're arguing now. Second, Alabama's own expert used the approach Alabama now attacks. Third, no state actually requires what Alabama wants. Fourth, Alabama itself doesn't follow the rule Alabama proposes. And fifth, deciding the case would require creating new constitutional law rather than clarifying existing law.
That perfectly captures it. This case presented every reason courts use to justify a DIG. The question wasn't actually litigated below. The parties shifted positions between trial and appeal. No real circuit split or disagreement among courts existed to resolve, and deciding the case would require making new law based on arguments never presented to the lower courts.
So the court dismisses the case as improvidently granted.
2 sentences. The writ of certiorari is dismissed as improvidently granted. It is so ordered. That's the entire per curiam opinion. No explanation. Just acknowledgement that the court shouldn't have taken the case.
But Justice Sotomayor wrote separately.
She did, joined by Justice Jackson. Her concurrence explains exactly why this case presented a poor vehicle. She walks through all the problems we just discussed. That all parties agree no single mandatory formula exists for weighing multiple IQ scores, that Alabama never argued below what it argues now, that none of the experts used the methods Alabama claims necessary, that Alabama didn't appeal on this basis to the 11th Circuit, and that no state or federal court has adopted Alabama's proposed rule.
And she responds to the dissent?
She pushes back hard. The dissent argued the court should have provided guidance to lower courts struggling with multiple IQ scores. Justice Sotomayor responds that there's no evidence lower courts actually struggle with this issue. No circuit split exists, state and federal courts haven't expressed confusion, and only 43 Atkins cases nationwide involved multiple IQ scores in the 12 years since Hall versus Florida came down. What about the dissents? Justice Thomas and Justice Alito both wrote separately.
Justice Thomas writes separately to argue the court should overrule Atkins versus Virginia entirely. He believes Atkins represents improper judicial lawmaking, the court inventing a constitutional prohibition that doesn't exist in the Eighth Amendment's text or history. He argues the founding generation understood cruel and unusual punishments to forbid only particular methods of execution deemed torturous, not entire categories of defendants. Since no jurisdiction prohibited executing intellectually disabled offenders when the Eighth Amendment became law in 1791, Thomas concludes Atkins lacks foundation in text, history, or precedent.
And Justice Alito's dissent?
Justice Alito, joined by Justice Thomas throughout and by Justice Gorsuch as to parts 1 through 3, argues the court should have decided this case and provided guidance. He contends lower courts face recurring confusion about evaluating multiple IQ scores, and this case presented an ideal vehicle for clarifying proper methodology. He walks through professional literature from the American Psychological Association, explaining how clinicians approach multiple scores, discusses issues like practice effects, meaning scores tend to rise when someone takes similar tests repeatedly, and argues the district court and 11th Circuit applied a flawed methodology.
But isn't that exactly the problem Justice Sotomayor identified? Alabama now wants the court to adopt detailed methodological rules that Alabama never asked for below?
That's her point. She argues in her concurrence that she's not shifting the burden to Alabama. Everyone agrees Atkins claimants bear the burden of proving intellectual disability. But the way this case got litigated renders it inappropriate for the court to adopt specific rules about combining multiple IQ scores because Alabama never urged such rules below or on appeal. The dissent wants the court to announce detailed statistical requirements, but no party advocated for those requirements in the lower courts.
So what actually changes after this decision?
For Joseph Smith specifically, this means everything. The dismissal leaves the 11th Circuit decision intact. Smith remains protected from execution as intellectually disabled under federal constitutional law. Alabama cannot execute him based on this record. That protection survives.
And for future cases?
The dismissal leaves uncertainty in place. Courts still lack Supreme Court guidance on how to evaluate multiple IQ scores beyond the general principles from Hall versus Florida and Moore versus Texas. The holistic approach validated by the 11th Circuit, considering all scores together with expert testimony, measurement error, and adaptive functioning evidence, remains permissible but not mandatory. States retain flexibility to adopt various methodologies as long as they don't rigidly ignore measurement error, which Hall prohibited, and as long as they follow current professional standards rather than outdated criteria, which Moore required.
Noe, what about the deeper implications? The dissents signal vulnerability in Atkins' doctrine, right? Absolutely. You've got 2 justices, Thomas and Alito, writing lengthy dissents criticizing the dismissal. Justice Thomas explicitly calling for overruling Atkins. Justice Alito warning that continued confusion invites fundamental challenges to the doctrine. Justice Gorsuch joining significant portions of Justice Alito's dissent. These signals suggest at least some justices view Atkins' implementation as problematic and may welcome opportunities to reconsider the doctrine's foundations.
That could affect how capital defense attorneys and prosecutors approach future Atkins cases.
Definitely. Defense attorneys gain validation for holistic approaches that consider measurement error, expert interpretation, and evidence beyond raw numerical scores. Prosecutors face continued difficulty defending rigid cutoffs or rules that mechanically prioritize certain scores over others. But the court's deep division and the warnings in the dissents suggest the doctrine faces potential instability going forward.
What questions did the court leave open?
Everything the court granted review to decide. Whether courts must combine multiple scores using specific statistical methods. Whether certain methodologies prove more scientifically sound than others. How much weight courts should give to practice effects when later scores exceed earlier ones. Whether measurement error should cut in both directions equally. All these questions remain unanswered, leaving courts to navigate them case by case using existing precedent and professional standards.
So this DIG basically preserves the status quo. Smith keeps his protection, but no new law gets made?
Exactly. The court concluded after oral argument that this case couldn't properly resolve the questions it presented. Better to dismiss and wait for a cleaner vehicle than to decide based on arguments never litigated below. Sometimes the right answer involves acknowledging you picked the wrong case.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
Talk to you soon.